The tenancy reforms in the Renters' Rights Act are due to come into force on the 1st of May 2026. But did you know that if you don't update your tenancy agreements for new tenants to include a whole raft of new compulsory terms or serve a separate written statement, and you keep on using your existing AST, you could receive two separate sets of penalties of up to £7,000 from the local council? And there's been so much talk about the abolition of Section 21 and how landlords will need to allow pets, etc., unless they have a good reason to say no. But almost no one is talking about how the Renters' Rights Act, it goes so much further than that. And that's the point of this video. I explain exactly what the rules are so that you know what to do and you'll have one less thing to worry about. Well, who am I? I'm Suzanne Smith, a former corporate solicitor turned landlord, and I run the Independent Landlord website and this YouTube channel to bring reliable, practical information to everybody in the private rented sector. And I've also just published this book here, The Good Landlord Handbook, that takes you through everything that you need to know about how to operate successfully under the Renters' Rights Act, and it follows each stage of the tenancy. You can buy it on Amazon or by using the link below. And to keep up to date for free, you can sign up for my free weekly newsletter at theindependentlandlord.com/subscribe. Right, let's get started. First of all, what is this new assured periodic tenancy? Well, at the stroke of midnight on the 1st of May, all existing ASTs will become assured tenancies that are periodic, which the government is calling assured periodic tenancies, or APTs. And ASTs won't exist from the 1st of May, as Section 2 in this Renters' Rights Act removes the entire chapter of the Housing Act 1988 that creates ASTs. So there's no option to keep them. The tenancy will continue, though, and the old AST will be treated as one single ongoing tenancy with the APT, but the fixed term will end and the tenancy will become periodic. And we won't need to reissue documents like the gas safety certificate or reprotect the deposit. Also, if you already have an AST in writing, you won't need to do anything other than serve what's called the information sheet, which will be published on gov.uk sometime in March. And when that happens, I'll put out another video. So this means that you don't need to issue a new agreement. But the big change is that for new tenancies which are entered into, that means signed on or after the 1st of May, landlords will need to give tenants what's called a written statement of terms to the prospective tenant, and before they sign the tenancy agreement. And if you don't do this, you can receive a civil penalty of up to £7,000. And that's the first of the civil penalties that I mentioned. The simplest way to serve the written statement of terms is to include it in your new tenancy agreement, an APT, which is exactly what I've done for the template assured periodic tenancy agreements that I've produced for members of the Independent Landlord Hub to use. So let's go on to exactly what this written statement of terms is. The government has published a statutory instrument that sets out the terms and information that landlords must provide tenants. It includes many terms that won't be in your existing AST. For instance, a clause saying that rent can only be increased by the process under Section 13 of the Housing Act. And I covered this in my book in detail, but I'll go through it now. The various terms and information that you need to include in a written statement fall under 5 categories. And if we miss one of these terms, we might get a civil penalty of up to £7,000 from the local council. The first category is the details of the parties. That's straightforward. Names of the landlord and the tenants, address for service of the landlord. That's not necessarily where they live, but it's the Section 48 address for service. It can be the agent's address or another service address. And number 2, the tenancy terms. So this is when the tenancy starts, what the rent is, when it's payable. And remember that rent can't be for more than 1 calendar month at a time for new tenancies from the 1st of May, and it can't contractually be payable in advance, although a tenant can voluntarily pay in advance as long as it's after the parties have entered into the agreement. And as I mentioned, any increase in rent must be pursuant to a notice proposing a new rent in accordance with Section 13 of the Housing Act 1988. And that will be in a new Form 4A that will be published on gov.uk. You'll need to list any bills that are included in the rent and give full details if the tenant needs to pay the landlord for bills other than rent. Also, the minimum notice period that the tenant must give to serve a notice to quit to terminate the tenancy must be included. And this will normally be 2 months, and it can't be for more than 2 months. And I have wording to say that it needs to expire at the end of a rent period. The final thing in this category is the amount of the tenancy deposit. You don't need to say the name of the scheme, but it's okay if you do. The prescribed information should be served separately after the deposit is paid, or if your tenant has already paid you the deposit, you can then include it in the agreement. The third category is ending the tenancy. There must be a statement explaining that the landlord can only bring the tenancy to an end by obtaining an order for possession from the court of the property and execution of the order after having first served a notice under Section 8 of the Housing Act, relying on a valid ground for possession. Number 4, the safety and compliance information. We need to include specific clauses saying the landlord is obliged to ensure the property is fit for human habitation and that the landlord must keep the property in repair under Section 11 of the Landlord and Tenant Act 1985. You see, it's very specific, and safety obligations regarding electrical installations and gas fittings and flues. The final category is tenants' rights. There are 2 rights that tenants have that need to be mentioned in the written statement of terms. The first is the right to keep a pet under the new Section 16A of the Housing Act 1988. And the second is about their rights under Section 190 of the Equality Act 2010 to apply to make improvements for a disabled person. And if you don't have all of these clauses in it, in the statement of terms or in your tenancy agreement, if you want to include it in the same document, then you can receive a civil penalty, as I said, of up to £7,000. So that's the compulsory information. What must you not include in new APTs entered into from the 1st of May? Well, from the 1st of May, landlords must not purport to let for a fixed term. So an example of this would be for if you enter into a new agreement using an old AST or a homebrew agreement that you've done yourself, which includes a fixed term. Because if it includes a fixed term in it, which ASTs invariably do, that will be a breach of this duty not to let for a fixed term, and the landlord can receive a civil penalty of up to £7,000. Also, don't include the right for the landlord to terminate with 2 months' notice. You often see these in ASTs, and if you try to rely on that, you'll breach the duty not to purport to bring the tenancy to an end by service of a notice to quit. And as an aside, if you have one of these clauses in your existing AST and you try to enforce it by you serving a notice to quit on a tenant, that's a breach with a £7,000 civil penalty. And there are lots of other clauses that you shouldn't put into new APTs from the 1st of May, although they're just unenforceable rather than attracting penalties. For instance, if you have a rent review clause, that will be null and void. And clauses that will require tenants to pay rent in advance, apart from the payment of the initial rent, that's between when the parties have signed the agreement and the start of the tenancy. If you ask tenants to pay rent in advance in the tenancy agreement, that clause is not enforceable. And if you ban pets, unless you have a good reason, like you're a leaseholder with a lease that says pets are banned, then that clause will be null and void. So the Renters' Rights Act is complicated, And I know that landlords need a readable guide that explains the rules, putting it into context, focusing on the practicalities. And I mentioned it before, but this is why I have published this book, The Good Landlord Handbook. And it's a practical guide covering every stage of the tenancy, from finding tenants to the end of the tenancy, and it integrates the Renters' Rights Act all the way through it. And everything I've talked about today in this video, the assured periodic tenancy and the written statement of terms, it's all covered in detail in this book in a very straightforward and readable way. It's available now on Amazon and on my website in paperback and as an ebook. And I'll put a link in the description below. And for those of you who want the practical tools to go along with the knowledge, then in my membership, the Independent Landlord Hub, I've got a template assured periodic tenancy agreement and a standalone written statement of terms that you can download and use from the 1st of May. There's a lot of checklists and you can ask me questions at twice monthly webinars. So if you want to hit the ground running, it's there for you, theindependentlandlord.com/hub. And see you soon, and hopefully in the hub.